Hi, I'm carrying on with pure economic loss and negligent statements. So remember the Caparo Test, things about fair, just and reasonable, things, being proximate, the assumption of responsibility. It's difficult to think how these terms should be used. There was an important case called Customs and Excise Commissioners against Barclays Bank, 2006. It went to the House of Lords. The claimants had a freezing order on the assets of two companies to protect VAT payments that they were owed by the claimants. The orders should have let the banks know they mustn't permit the companies to withdraw money from these accounts. However, the companies managed to withdraw large sums, and the commissioners were then not able to get the money back. So the judge, at first instance, he found that the defendant bank didn't owe a duty of care to the commissioners. But the Court of Appeal said that no, they did owe the duty of care to the commissioners because of the assumption of responsibility by the bank. So when the freezing order was served, the Caparo test ought to have kicked in, fair, just, and reasonable. So when thinking about whether there's proximity, courts will look for a special relationship, and this is something which is contextually judged. Lord Bingham said the results seem to be reached whenever this formulation is used. So the House of Lords had overturned the Court of Appeal finding of liability and said the trial judge's decision was correct. There was no common law duty of care to arise because of a freezing order. The Headley-Burn special relationship is not something we can prove too easily. It's not just because of reliance. The commissioners do not rely on the defendants to comply with the order. The commissioners depended on the courts to enforce that order. It's got to be fairly voluntary for it to be said there's an assumption of responsibility. In this situation, the defendants had a freezing order imposed on them by the courts. So voluntary assumption of responsibility is there. It might be enough to impose a duty, but that's not always a condition of liability. If there's a voluntary assumption of responsibility, this test doesn't always give us an obvious answer. Remember, the Caparo tripartite test is something that's applicable, and also policy reasons must be taken into account. Lord Bingham said, "I think it is correct to regard an assumption of responsibility as a sufficient but not a necessary condition of liability. A first test which, if answered positively, may obviate the need for further inquiry. If answered negatively, further consideration is called for." This is what Lord Hoffman had to say about it. There is a tendency, which has been remarked on by many judges, for phrases like proximate, fair, just, and reasonable, and assumption of responsibility, to be used as slogans rather than practical guides as to whether a duty should exist or not. These phrases are often illuminating, but discrimination is needed to identify the factual situations in which they provide useful guidance. The answer does not depend upon what the defendant intended, but, as in the case of contractual liability, upon what would reasonably be inferred from his conduct against the background of all the circumstances of the case. So anyway, the West Bromwich Albion case and the Caparo three-part test, well, it was applied then. So the foreseeability of loss by claimants is important. Proximity also matters, but proximity is sometimes dubious. What's vital is it wouldn't be fair, just, and reasonable to impose a duty of care. If it's not all those things, fair, just, and reasonable, there's no duty of care. So a duty would make banks liable for sums in response to trivial mistakes on their part. There are better ways to resolve this rather than the law of tort, to uphold proper standards in banking law. That's enough. Bye.